we're going to get started. Good afternoon. Welcome to the Bernkopf Goodman webinar, Reopening the Massachusetts Construction Industry, the End of the Beginning. Thank you to everyone who sent questions ahead of time. Peter and Bob received those questions and they're going to work them into their presentation. We will also have a question and answer session after the presentation. Please use the Q&A section to submit your questions and our speaker will answer as many of those questions as possible at the end. The purpose of this presentation is for information only. Communication with any member of Bernkopf Goodman LLP in this forum does not establish an attorney-client relationship. Confidential or time-sensitive information should not be discussed on this forum. Speaking today, we have Bernkopf Goodman litigation partners Peter McGlynn and Bob Stetson. Both Peter and Bob are members of Bernkopf's Construction and Surety Law Practice Group. They are both fellows in the Construction Lawyers Society of America and have both been recognized on a national level for their work in construction litigation and commercial litigation. Peter McGlynn also has extensive bankruptcy experience and is certified in business bankruptcy law by the American Board of Certification. Peter, why don't you kick it off?
Good afternoon, ladies and gentlemen. Thank you all for attending. We really appreciate it. It's been 2 months since we had our first pandemic COVID-19 webinar with you folks. A lot's happened, but a lot hasn't happened. Obviously, what hasn't happened is the resumption of construction work, for the most part, in the entire Commonwealth. At that time, we reported on the suspension orders from the cities of Boston and Cambridge, as well as the emergency order from Governor Baker, which initially opened construction work throughout the Commonwealth and then subsequently suspended it. Now, 2 months later, a little bit of good news. This past Monday, May 18th, Governor Baker announced that all construction work will be allowed to reopen, but subject to mandatory safety standards for all industries, and then a set of construction-specific mandatory safety guidelines and guidances and standards issued on May 18th. My partner, Bob Stetson, will provide you with an overview of these mandatory requirements. I believe we've provided all of you, the invitees, with a link to these standards and guidances in our electronic invitation. These requirements must be put into place before a construction site is allowed to reopen. Also, this past Monday, again, May 18th, the City of Boston greenlighted the reopening of construction work in hospitals, public schools, 1 to 3 unit residential buildings, and road and highway and utility construction, as well as certain work that's capable of being performed outdoors, such as steel erection. Next Thursday, May 26th, all construction projects in Boston may reopen, but they must comply with the Baker-Polito standards and guidance, which I just discussed briefly, and Bob will talk about a little bit more in detail, as well as Boston's COVID-19 safety plans. Boston is requiring an affidavit certifying compliance with these guidances. That affidavit must be filed before work can commence. Cambridge hasn't issued anything new since April 2nd, and at that time, Cambridge required essentially that contractors follow distancing, social distancing, and sanitation requirements, and promote a greater awareness throughout the job site of the symptoms for COVID-19, as well as proper hand washing techniques and daily wellness checks and so on. May 7th, Somerville released its 4-phase plan. I'm not going to discuss in great detail all 4 phases, but essentially they're talking in Somerville about a phased approach beginning this past Monday, allowing, quote, highly critical projects, undefined, but primarily municipal and utility projects to begin, and then ramping up to phase 2 on June 1 for additional municipal and utility projects, and then through July and September, other capital projects that are currently in the design and bidding stage. Phase 4, there has been no start date set, and what additional construction will be allowed in phase 4 has not as yet been determined by the city of Somerville. You can anticipate that once this rolls out a little bit further, other cities and towns will join with their brothers and sisters in Cambridge and Somerville and Boston and implement their own either project-specific or location-specific rules and regulations. Now, given that there is some conflict between what Governor Baker and Lieutenant Governor Polito have issued in terms of their standards and guidances and what cities of Cambridge, Somerville, and Boston have already issued, the question has been raised as to which of these or all of these must be followed. For those of you who attended our March 23rd webinar, you may recall the discussion we had concerning the conflict between what Governor Baker had originally ordered, namely that all construction work throughout the Commonwealth could begin, and the City of Boston's suspension order that said no work other than COVID-19 essential services work could begin. At that time, we discussed these potential conflicts, and we thought then, and we still do, that the state's emergency order, which was promulgated under a 1950 Civil Defense Act, trumped any conflicting orders issued by the cities of Cambridge and Boston. Ironically, 2 days later, after our program, the governor's chief legal counsel issued a directive to all cities and towns, ordering them to immediately withdraw all rules and regulations that conflicted with the governor's emergency order. But that's where the issue was left. Governor Baker did not take any further steps to enforce that withdrawal order, and of course, subsequently decided to suspend most of the construction work that he had previously allowed to open about a week later. Now, in case of the safety standards and guidelines issued by Boston, Cambridge, and Somerville, as well as the Commonwealth, what guidelines, what standards have to be followed? And the line between the two or the three become a little bit more blurred. State standards and guidances, as Bob will tell you, provide extensive and comprehensive rules and regulations which must be followed. They are mandatory. But local requirements may be even more so and may be even more specific either to the particular geographic location or the specific project. And indeed, there may be some unique COVID-19 problems within these local communities that they're trying to guard against. The state regulations also vest with the local cities and towns through their public health officers, as well as their building inspectors and other, quote, appropriate officials. They have the power to regulate and enforce these rules and regulations at that level. Thus, we think the safest approach here is to follow all of the regulations, state and local, and similar to what you might do on a construction site, if there's a conflict between plans and specifications, you request a clarification. Request that clarification from the local building inspector or the local public health official. They're there, at least by virtue of what we read from the State House, from Governor Baker and Lieutenant Governor Polito, that they're here to try and help. This is not to try and put the handcuffs on anybody unless there is severe and repeated violations. So that gives you a rough idea of the landscape. And at this particular juncture, I'd like to turn it over to Bob, and he'll share with us all some more specifics about these guidelines. Bob?
Thank you, Peter. You're right, these standards are extensive. This is a very brief overview, and one that I think many of our viewers probably could have predicted a lot of these standards. They include social distancing measures, laborers to use cut-resistant gloves and masks. There must be limited use of break and snack areas. A site-specific COVID-19 officer must be employed at each site. COVID-19 certifications addressing whether laborers have been exposed to the virus or have a fever. A site-specific risk analysis and safety plan is going to be required in certain instances. Local Board of Health notifications in the event of an exposure on a project site. Extensive disinfecting measures, and hand washing stations. Peter, the item that stuck out to me on this list was the site-specific risk analysis and safety plan. what is your understanding of when that is going to apply, and what do you see that including?
The Commonwealth says that with respect to large, complicated construction projects, which they don't define, cities and towns may require that the owner develop site-specific risk analysis as well as enhanced COVID-19 safety plans. It's not mandatory, but likely will be required at the local level. However, it's important to note that once that plan has been approved by the city or town, a violation of that plan shall be treated the same way as a violation of the COVID-19 mandatory construction safety standards and guidances. And since, for example, Boston and Cambridge require project safety and work plans, and Boston in particular requires a compliance affidavit be executed and completion of what's known as a best practices worksheet, which is a multi-page worksheet, check the box, yes or no, it's reasonably clear that local should be sought.
There was another thing, Peter, that stuck out to me. There was an awful lot of chatter in the construction world the past couple of months about thermometer stations. But as I understand it and read, Governor Baker's standards don't address thermometer stations. Do you think they're going to play any role going forward?
In a word, yes. As I mentioned a few minutes ago, Boston has this best practices worksheet, and by way of example, there is a question on that particular worksheet about whether or not the contractor or the owner is going to have temperature checks on the project site. Check box, yes or no. If you check no, there is a requirement that whoever is filling this sheet out must justify the no answer and include an alternative approach. We also know that given the work that has been ongoing, obviously so-called essential or emergency services, that contractors are becoming more experienced in these safety protocols and procedures. And we know a number of them, especially on the larger projects, have set up temperature check stations on their job sites already. Now, the COVID-19 pandemic has seriously impacted the U.S. economy, and I think it's fair to say that the construction industry ranks right up there at the top of the list as one of those industries that has been impacted very severely. Boston alone, for example, over the past 2 months, approximately $8 billion worth of construction work has been suspended. So you can imagine the financial implications that have been attended with that shutdown. And these new mandatory standards and guidances that have just been issued in the last week or so will likely cost more money to implement, and will likely render the work on the project site less efficient. Lost productivity, of course, is the bane of any construction project, and there is going to be a loss of productivity as a result of these new guidelines. Standing alone, the cost is going to be significant. I just talked to a client yesterday on a large project in this region, and just the cost of implementing the safety standards, putting aside productivity and time issues, is going to be about $200,000. And of course, reduced productivity also means more time and more money. So Bob, with that backdrop, would you share with our viewers your thoughts on who pays for these additional costs?
Yeah, I mean, I think it's interesting. Historically, it's unusual for a change of the magnitude of what you just mentioned, $200,000 for some additional scope on a project to come from anywhere other than the owner. Nevertheless, I think at a fundamental level, Governor Baker's standards represent something akin to a typical project scope change. So, I suspect that most reasonable change orders for additional costs and time, insofar as they're related to the actual compliance, as you just mentioned, will be processed in accordance with the change order provisions in any given contract. If you're using the AIA A201, this is going to be in your Article 7 and then Article 15 for claims if there's a dispute. Now, there are going to be times when the contractors are going to get pushback from owners. There may be some heavily edited change order provisions. And if there is a sharp disagreement on a project, I suspect the next battle lines are going to be in the emergency provisions in the contract. You know, for instance, in section 10.4 of AIA A201, which I have right here, I'm going to read it. It says, quote, "In an emergency affecting safety of persons or property, the contractor shall act at the contractor's discretion to prevent threatened damage, injury, or loss." Here's the key part. "Additional compensation or extension of time claimed by the contractor on account of an emergency shall be determined as provided in Article 15 and Article 7. You and I have had this discussion before, Peter. I think most of us view this provision as, you know, covering emergencies that have some immediacy to them, a collapse risk, you know, a hurricane bearing down on the coast. But I think the language, at least from a textual perspective, is not so limiting, and at least in the AIA context. So I would expect to see some disputes over this language in the future. I also think that moving forward, the next question, now that we all know about the pandemic, we know that additional shutdowns, potentially additional guidelines and standards may be required in the future. I think that changes things. And you know, for owners and contractors, Peter, that are in the middle of contract negotiations or will be in the middle of contract negotiations, you know, in the midst of this pandemic, how do you see those negotiations going? How do these issues get addressed?
Well, I'll speak to it a little bit later on, just further to your comment, you know, the emergency provisions are kind of the road less taken, but I suspect now if that becomes an issue, that road will become trampled and very crowded. But to your question, from what I've seen so far, it's been kind of a two-step or a multi-step process. When all of this arose, owners and developers, owners and contractors took whatever steps they felt were necessary to protect their rights, you know, under the notice provisions of the contract. We've been delayed. We don't know what the cost is going to be. We don't even know when the delay, excuse me, is going to end, but here's your notice. But since then, there has been more of a collaborative approach. Everybody kind of understands that we're all in this together, and it doesn't make a lot of sense to start launching battles about who gets to pay or has to pay what and who doesn't. That may come later on down the road, but at least at this point, the energies, time, money, et cetera, are being spent on taking a collaborative approach to get these plans implemented so everybody can reopen their projects and get back to work. And then maybe the funds get fronted under a reservation of rights or some such thing, but that work will go on, and I doubt very much that people are going to be spending a lot of time right now arguing about it. Now, in terms of your other question or your other point, how do you deal with this from a contractual standpoint? Well, the standard form contracts now that we've all been used to, the American Institute of Architects contracts, a lesser used standard set called consensus docs, as well as contract clauses in state and federal governments, is going to be it's going to be something that people are going to look at. But the general concept there is that if there has been a time extension, the concept is going to be that the project or the time and the money will be equitably adjusted. That's a term that's used in these contract provisions. And literally there have been thousands of cases that have been decided over the past 70 years on this concept, all on this issue of what constitutes equitable adjustment. We could spend a whole day on this program discussing that, which we don't certainly have time to do. But the point is that it is a concept that's out there, but it's not crisp, and ultimately if there's a dispute, if you leave it that way, you're going to have a judge or a jury or an arbitrator that's going to decide exactly what you're entitled to. So I think the better course of action here is to deal with this now in a finite and clear way, whether it's by way of unit prices, or a per diem amount or some other formula to measure what you do and how you price all of this out during one of these events. I don't think it's certainly very different, and this is unique. But for example, if you're building a building down in southern Florida, which is susceptible to hurricanes, most of the contracts down there you're going to see with hurricane rules and regulations and what types of time extensions and what types of costs will be built into that contract in the hopefully unlikely event that you have a hurricane. Or if you're in a cold weather climate or earthquakes, that type of concept certainly can be embedded into future contract negotiations here. So I think that these principles can be applied to this pandemic. Hopefully it never repeats itself, but unfortunately we're here and dealing with it now. Only time will tell whether or not and to what extent these guidelines and these guidances will be effective. And of course, how much they cost in terms of actual out-of-pocket costs, in terms of lost productivity, and of course, the time impacts. As the learning curve on these standards and guidelines increases, owners and contractors will learn how to implement them cheaper and more efficiently. But for the foreseeable future, these standards and guidances and regulations are going to remain in effect, and contractors should consider that this is going to be, moving forward, a cost of doing business, and should certainly be aware and craft appropriate contract language to meet these conditions, Bob.
What if the costs become so significant and contractor says, or maybe even an owner says, you know what, I'm not paying for it. And so they don't do anything and they ignore the standards. What's the enforcement mechanism here envisioned under these standards?
Well, as I said earlier, Bob, it's like Tip O'Neill said, all politics is local. Well, in this case, all enforcement is local. It's vested within the cities and towns by Polito and Baker. But what happens? Well, they're taking a very soft approach. The Lieutenant Governor spoke on this on the 18th, this past Monday. And basically, if there has been a violation, the first step will be to essentially inform and perhaps educate the violator. They may hand out some kind of a pamphlet saying these are things that you have to follow. If there has been a repeated violation, ultimately there may be a fine of up to $300 per day per violation, and that could add up fairly significantly. But the point is that this is not a desire by the state or the local authorities to exercise strong-arm police power tactics. It's really obviously to preserve the safety of the project site and, of course, all of the people that are working there. Businesses will be given, or contractors will be given a 24-hour cure period before a follow-up inspection occurs. So it's obviously an effort to try and educate people and to bring them up to speed, because obviously we're all experiencing this for the first time. At the federal level, for example, OSHA has largely taken a hands-off approach to these guidelines, at least at this point. So we'll see, time will tell. Now, kind of what segues into that is not only the adherence to these rules and regulations, but obviously there are other potential issues here too. For example, and Bob and listeners, you have a construction worker on the site and he contracts COVID-19 and he's out of work for weeks or months, loses his pay. What happens? Does he have any recourse against the contractor? Can he collect insurance? And then similarly, if somebody gets exposed to COVID-19 on a work site and comes down with COVID-19, does that particular third party have any remedies? Is anything like that covered by insurance? So I'm sure you have some answers to that, Bob. To those.
Well, I have some opinions, some thoughts. I think there are really kind of three issues that are tied into that question. and the first is, the workers' compensation issue. You have an employer who has a sick worker. Is the worker covered? Now, Massachusetts workman's comp has always covered infectious disease, but, and this is a big but in this instance, only when the hazard of contracting the disease is inherent in the employment. So, hospital worker in a COVID-19 dedicated ward, for instance, might have a straightforward comp case. Construction worker on a project, I think that's a substantially more difficult argument, and I think there's going to be a fair amount of pushback from the insurers in that regard. I think the second issue, and it feeds into the third, is the tort lawyers. The tort lawyers are going to try to get their pound of flesh here one way or the other. There's already been some cases.
I'd like to say, Bob, that they are properly and vigorously advising and helping their clients.
Well, I think that, I think in certain instances, but, undoubtedly there will be some abuse as well, Peter. And I'm quite confident that the cases that have been filed so far are just the tip of the iceberg. You mentioned the contract. Let's give a real world example. Let's assume a contractor fails to, disinfect a high touch area on the project as is required under the standards, and there's an outbreak. I think the tort lawyers are going to be lining up to sue the contractor and, going after the insurance companies. There will be problems of proof. How do you prove that you caught COVID-19 at the job site? And, the chatter in legal circles and the conventional wisdom at this point is that that's going to be very difficult to prove. I actually don't necessarily agree with that. I did have my phone around here. We have these neat little tracking devices basically on our person 24 hours a day. We know where people are, when they are, and I suspect that at least in the next few months, people are going to be a bit more cautious about where they go. So, Peter, I actually think it's going to be a little bit easier to prove the genesis of a COVID-19 case than most people think. What's going to be interesting, in my opinion, is to see the scope of these claims, whether, for instance, we're going to start seeing, claims filed for secondary infections, like if a laborer's family or friend ultimately gets sick. I think that is going to present some very interesting questions going forward, both from a legal as well as a factual standpoint. I think the third very closely related issue to that is whether or not the CGL, the Commercial General Liability Insurance, is going to provide indemnity and defense to these businesses that are sued. The standard for determining whether or not there's coverage in this instance is whether the personal injury is caused by a quote-unquote occurrence. Like change orders, there's hundreds, if not thousands of cases that have interpreted that. But taking the example I just posed, failure to clean the project site in accordance with some government issued standard, that's probably going to fall within that definition. That being said, many CGL policies, and this really does vary from policy to policy, so it's important to take a look at what kind of coverage you have. Many CGL policies have exclusions for communicable diseases, organic pathogens, and other similar exclusions that I could foresee insurers pointing to, saying, hey, we're not getting involved in this. I don't know that it's necessarily a separate issue, but there is an elephant in the room in this discussion, and it's whether or not legislatures are going to provide some kind of immunity. On March 17th, 2020, for instance, the Secretary of Health and Human Services, they published an emergency declaration which immunized certain entities involved in providing countermeasures for COVID-19. I think that the insurance companies and business owners across the United States are going to be lobbying hard for those types of protections on a much broader scale. And I know that, just in the news recently, Senator McConnell recently called for that legislation to be part of any new relief package. So I think it's very much a possibility, and it's going to be interesting to see if the government steps up to aid insurance companies and businesses, because this expected wave of tort litigation is certainly coming.
Well, that's a brilliant segue into our next topic, Bob, and that's business interruption insurance.
Almost like we planned it.
You know what? Absolutely. Business interruption insurance, Bob, you talked about it during our March 23rd webinar, and the prediction was that the potential for recovery under most BII policies for COVID-19 was pretty bleak. So now we're 2 months on from when all of these problems have arisen. So let's revisit and see what's happened out in the world of insurance litigation on BII coverage. We did a little count, and thus far there have been in excess of 170 lawsuits nationwide that have been filed against insurance carriers by individual policyholders. And add to that, there have been a number of efforts to get other policyholder groups certified as class action litigation. Right now, I think Pennsylvania leads the way with over 20 lawsuits. California is down around 18. To our knowledge, there's only been one, at least, that's been publicized in Massachusetts. I'm sure many of you saw it in the paper and on the news broadcast, the BII client lawsuit filed by Legal Seafood. We took a look at that complaint, and like the company, the complaint is like a seafood buffet of all of the various types of claims that can be asserted or are being asserted to try and find some liability under these BII policies. I won't go through, and this is not going to be a webinar on BII litigation, but there are various causes of action that have been alleged in all of these complaints, and in just about all of them, and in particular the Legal Seafood case. One is that the presence of COVID-19 on a desk or on a chair or a bar stool or something like that constitutes quote unquote property damage, which thereby triggers the property damage portion of the BII coverage. There's another argument out there that the mere presence of COVID-19 in the air constitutes property damage. There's another one, the so-called civil authority theory, where by virtue of all of these shutdowns due to COVID-19, that people can't get into their places of business and therefore have had a loss of business. There's a theory that that can trigger a BII claim as well. And then finally, there is this kind of joinder of all of these claims and essentially saying that the conflict between providing coverage and all of these other exclusions is so confused and conflicting that the insurance company should be liable to pay, and that the policy of insurance should be construed in a light least favorable to the insurance carrier. None of this has been decided as yet, and of course these cases will wend their way through the courts over the next months and perhaps years. The issue is a practical one, and that is even though most of us think of insurance carriers as these huge monoliths that have billions and billions of dollars, and of course many of them do, but a lot of these specialty carriers that handle business interruption insurance are not very big at all. And if they're forced to defend hundreds, if not thousands of these lawsuits, the legal fees are going to be enormous, and they may face what's called liquidation. That's how insurance companies go out of business at the local level through the insurance commissioner's office. That's not going to be good for anybody. So as Bob alluded to, there may be some federal assistance there that might be available. Nothing yet, but that's something that likely will come if this becomes a huge, huge problem. But there are also some alternative concepts and theories as well. And these, I think, are starting to develop. We've heard of a couple, but it's Alexander Graham Bell famously said about 100 and some odd years ago, and I quote, "When one door closes, another door opens, but we often look so long and so regrettably upon the closed door that we do not see the ones which open before us." And I think as we discussed, and particularly Bob, the tort lawyers have been incredibly creative over the years in finding new paths that haven't been tested, haven't been tried. This has happened throughout our history, beneficially so, in products liability and personal injury and so on. And I suspect that there will be other paths that will be taken to try and either work around the BII exclusions or to argue that these things should be covered in any event. But there are two other issues. One is, of course, errors and omissions insurance. It may very well be that companies relied on an insurance agent or an insurance advisor to provide them with coverage. Pandemics, virus, bacterium, it's unfortunate that it's been so severe, but it's not new, and insurance companies and insurance policies have dealt with this and provided these exclusions in there because of the potential that these would occur. So it's not something new that just fell onto the earth and we're experiencing now for the very first time. So the question is whether or not an insurance advisor or an agent should have alerted the company to that potential problem and at least advise the client to insure accordingly. And I think that's also going to be true at the corporate level. If companies are faced with catastrophic losses, if they've essentially been put out of business or lost huge business opportunities during this COVID-19 shutdown, there may be what's known as D&O claims against the officers and directors, essentially for failing to, so the claim would go to exercise prudent business practices and reach out and see what insurance products are available to provide for coverage for these particular events. Then there can be a weighing of factors, cost, risk, and so on. But those are other essentially workarounds, the potential exclusions of BII insurance. And I think that is the end of our program. And I know, Jeanette, you have an announcement as far as questions and answers.
I do. I know that a bunch of people sent in questions ahead of time, which it sounds like you hit all of those questions. If anybody else has a question before we wrap up, there's a Q&A button at the bottom. Just click on it, write your question, and we will answer it live. Right now, though, I don't have any in the queue.
Jeanette, yeah, I know we sort of briefly talked about the questions before we came on, but I'm not so sure that we did actually hit all of them. Maybe if you can just kind of run through them and just make sure that we've covered them.
Yes, bear with me.
Sure.
Steve Collins, do you have any reservations concerning requirements of the City of Boston's COVID-19 safety plan compliance affidavit?
Well, if you're signing an affidavit under the pains and penalties of perjury, and it's wrong or it's false, or materially false, you may have other problems other than a $300 a day fine. You know, that implicates criminal statutes, both state and local. So obviously, know what you're signing. Make sure that you have whatever backup there is to support whatever it is in the affidavit. So they wouldn't be requiring an affidavit under the pains and penalties of perjury if they weren't looking for comprehensiveness and complete candor and honesty.
Yeah, I concur.
Eric asked, are Congress and the White House considering backstopping business interruption insurance payments like flood insurance?
Well, we've heard about, I just alluded to it. I don't know that there's anything specific. Maybe Bob does, but I do not.
Well, there have been some proposals both on the state and federal level. I think probably the reason that they've been slow to move is that, you know, this actually, the flood insurance is a good example because the government there is actually acting more as like a market participant as opposed to, you know, directing you know, entities, companies, individuals to basically throw aside heavily negotiated agreements and rewrite them retroactively. I think there are a number of constitutional concerns, and there may be a way to structure it, to kind of withstand them. But I think that is one of the main reasons why they've been slow to move so far. Those resolutions.
Brian asks, what are the implications of a positive case on site with schedule impact? Will all COVID issues fall under force majeure?
Well, that's the starting point for sure. And, force majeure clauses are critically important under the circumstances. And, they really do need to be evaluated project to project. I happen to know which Brian asked this question, so I could say, please make sure that you look at these every single time. I do think there are probably some other provisions in the contract as well that may address this. We talked about 10.4 in the A201, which is the emergency provision. I think that if you have a really tightly wound owner favored contract, you may see contractors looking in the what are typically known as the environmental provisions, but the way that they're actually identified is, the hazardous substances or materials. You could see some creative arguments that COVID or that the virus is a hazardous substance. So I think there are probably a bunch of different ways to look at it for contracts that are already in place. But I think, as Peter pointed out, this is something that you really want to make sure that you're addressing going forward, because I think the element of surprise is something that, is fair now, but for contracts going forward, I don't think that, we're going to have that same surprise factor.
Let me just add, not all force majeure clauses are created equal. And
right.
What I'm thinking about in specifics is for about 60 years, maybe longer, public building contracts handed down by the Commonwealth of Massachusetts have basically said, we don't care what happens, hurricane, pandemic, volcanic eruption, earthquake, all you're going to get if you're delayed is a time extension. You are never going to get delay damages. Now, there have been creative workarounds, but that so-called no damage for delay clause has been in those public contracts 60 or 70 years or more. And so even if you have a force majeure event under those contracts, time extension only.
Good point.
Barry asks, I'd love to hear if there's a normal contractual language that allows general contractors to submit for added costs related to state and federal charges during construction. For example, added costs for PPE, lost productivity that have been only recently required after the original pricing is done.
Well, I talked about that earlier. Some of the standard form contracts provide for an equitable adjustment, depending on whether it's cost or time. And the courts have discussed this in great length over the last 60 or 70 years, what that entails. Really, the contractor is going to be made whole, but he's not going to have a windfall. But yeah, as I suggested, maybe you don't want the man or the woman in the black robe or the jury or the arbitrators to come up with their own interpretation of equitable adjustment. That's why the recommendation, Barry, is that you put it in the contract itself. If you're going to have a delay, maybe you put in a per diem amount for general conditions, or cap it, or some such thing. So the contractor is compensated for the out-of-pocket expenses, perhaps a time extension, but again, it's not going to be a windfall, and he doesn't essentially get every single conceivable dollar that he can load into the equation as recompense for this force majeure.
Yeah, and I would just add that, there are differences in the forms even on this particular issue. I think most of the forms, consensus docs, AIA, certainly, owner manuscript forms, they're all going to require the contractor to comply with the laws. And that includes changes in the law. And I think there are differences in how that's treated from a financial perspective. The AIA, it doesn't automatically trigger either a time extension or an additional contract amount. You would have to negotiate that. In consensus docs, I think that there is more of a presumption that you're going to get something if there is a change in the law. So that's another one where it's a provision that, during contract negotiations in years past, we might not look at more carefully. Certainly they need to be looked at very carefully going forward.
Yeah, I think that I don't want to prolong the answer here, but the federal government many, many years ago really kind of latched onto this concept of equitable adjustment. And they said, since all of their projects, like in the state, they're publicly bid, so everybody bids the plans and specs as well as the contract. And the federal government felt that they would provide a changes clause in their contracts to provide for this equitable adjustment, so that contractors, when they're bidding on the projects, don't put these huge contingency amounts in there, which may result in a windfall if the contingency never occurs. So get the contingencies out, allow them to get recompense for this event through the equitable adjustment / changes clause.
That's a very, very good point.
We just had another one come through on the Q&A section. Steve asks, how do these rules apply to multifamily housing over 3 units and general unit renovations, paint, flooring, etc.?
They apply. They apply across the board.
Yeah, I think one of the only differences is that you're not going to, you won't see the site-specific safety plan that Peter and I were talking about earlier on those smaller projects.
If you're building your dream house, you're not going to have to do that. It's probably best practices to do so, but I don't think that falls within the ambit of the regulations. But anything three houses or above, 3 units or above, it's applicable. They are applicable. Excuse me.
Jennifer asks, other than getting our own safety plan signed by subcontractors before they can come on site, are there any other measures that should be taken to limit liability from workers that are not our direct employees, other than ensuring a safety officer assigned by us enforces our rules? More specifically, are there other things we should do paperwork-wise for them?
Bob, you talked about the liability insurance. Why don't you take this one?
Yeah. Well, I think it really does start with your safety plan. I do think that if you've got a safety plan that's crafted around these standards, that's a terrific starting point. I think from the tort lawyer's perspective, each project is going to be different, and I think that if, for instance, you have a super complicated project and you're going to have 20 plus workers in a very small space, I think whether you're a large project or a small project, I think you're going to need to address that. You're going to have to take additional measures to ensure that everybody is adequately protected. Otherwise, there could be some exposure. From a paperwork perspective, most of the owner contractor agreements out there are going to require, the contractors to, take all security measures, safety measures and things. And those contracts are going to require that the subcontractor agreements incorporate those safety standards. So I think, as long as it's drafted appropriately, you've got your indemnity clauses set up correctly, you've incorporated your safety plans, I think that's about as much as you can do. I would say also on the insurance end, you just want to make sure that you go and speak with your insurance agent and make sure that whatever insurance that you're requiring subcontractors to have is going to be adequate to cover this, this potential risk.
Great. I don't believe we have any other questions. If anybody has a question after the fact, please reach out to both Peter and Bob. Their contact information was in the invitation that was sent out. You can also find them on our website, www.bg-llp.com. And thank you very much.